A very good day to everyone. Myself, Dr. Vibhuti Shivam Dubey, Assistant Professor, School of Management, BBD University, Lucknow. Today, I am going to discuss on a topic which is related with Bachelor of Commerce Honors course of the subject Income Tax Law and Practice and BCom 4302. The topic which we are going to discuss today is on residential status. So, before starting the topic, we will first discuss the content which we are going to discuss in detail. So, in today's lecture, we will be discussing about residential status, classification of person, individual, who is an individual, residential status of individual, Hindu undivided family, residential status of Hindu undivided family, company, firm or an association of person or body of individuals, and any other person. So, first of all, when we talk about residential status of an assessee is determined by the scope of chargeability of his income. Whether a person will be chargeable to a particular income or not depends upon his residential status. So, residential status is basically determined by in respect of the previous year, each previous year. In other words, we can say that the residential status of a person may vary from one previous year to another previous year. A person can have only one residential status for a previous year, that is, he cannot be a resident for one source of income and non-resident for another source of income. It is very important. So, when we talk about residential status, a person can be mainly classified into two parts: individual and Hindu undivided family, and other person. The classification or the main classification for residential status determination is, for as you can see from the chart also, that individual and Hindu undivided family can be classified into two parts: resident in India and non-resident in India. And again, as you can see that the resident in India, the residential status is decided on the basis of ordinarily resident in India and not ordinarily resident in India. And the second main classification, which is non-resident. In the other person classification also, the classification is mainly done in two forms: resident in India and non-resident. So now we will discuss about, first of all, individual, which is mentioned in section 6 subsection 1. An individual is classified as resident or non-resident. Resident individual may further be categorized as ordinarily resident or not ordinarily resident in India, as we have discussed in our previous slide in chart also. So when we talk about residential status and individual, in the case of individual under section 6 subsection 1, first of all, we will discuss about resident in India. When we say resident in India, if he satisfies one of the following basic condition, he will be categorized under the resident in India. The first condition is he is in India in the previous year for a period of 182 days or more under section 6 subsection 1a, or he is in India for a period of 60 days or more during the previous year and for 365 days, and for 365 days or more days during 4 previous year immediately preceding the relevant previous year under section 6 subsection 1c. So non-resident Indian, who is a non-resident Indian from the residential status point of view, and assessee who is not satisfying section 6 subsection 1 shall be treated as non-resident in India for the relevant previous year. There are some additional conditions also to test whether the resident individual is ordinarily resident or not, which is mentioned under section 6 subsection 6. So resident and ordinarily resident in India will be if he satisfies the following conditions. What are the conditions? He has been resident in India in at least 2 out of 10 previous years immediately preceding the relevant previous year, which are mentioned under section 6 subsection 1. or or he has resided in India for a period of 730 days or more during 7 previous years immediately preceding the relevant previous year. Resident but in the case of resident but not ordinarily resident in India, if a resident individual does not satisfy both additional condition as given under section 6 subsection 6, he is resident but not ordinarily resident in India. Now we talk about Hindu undivided family, which is mentioned under section 6 subsection 2. A Hindu undivided family can either be a resident or non-resident in India. Again, a resident Hindu undivided family can further be classified as ordinarily resident and not ordinarily resident, as we discussed in our previous slides also. So, resident Hindu undivided family, who will be resident Hindu undivided family? When the control and management, it is very important here that the control and management of affairs of Hindu undivided family is completely or partly situated in India during the relevant previous year, then only it is treated as resident in India. What does here control and management means? Control and management here means controlling and directive powers. Actual control and management, the place of central control and management is situated where the head and the seat and the directing powers are situated. So for control and management, which is mentioned here that the control and management of affairs of Hindu undivided family is completely or partly situated in India. So here clearly the control and management, the meaning of the control and management here is discussed. Next, non-resident Hindu undivided family. An Hindu undivided family is non-resident in India if the control and management of its affair is wholly situated outside India, then he will be considered as non-resident HUF. Ordinarily resident in India, if the Karta or the head of the family or manager of a resident Hindu undivided family satisfies both additional conditions given under section 6, subsection 6, Hindu undivided family is said to be an ordinarily resident. If the Karta or manager of a resident Hindu undivided family do not satisfy both additional conditions given under section 6, subsection 6, Hindu undivided family is said to be not ordinarily resident. So now we will discuss about company, which is mentioned under section 6, subsection 3, resident company. An Indian company is always a resident India, always a resident in India. A non-Indian company is said to be a resident in India if its place of effective management in that year is in India. Place of effective management, what is place of effective management here? As we have discussed here that Indian company is always a resident in India and a non-Indian company is said to be resident in India if its place of effective management in that year is in India. So what is place of effective management? Place of effective management means here a place where key management and commercial decisions that are necessary for the conduct of business of an entity as a whole or in substance made. Non-resident company, if place of effective management in that year is not in India, the said company is non-resident in India for the relevant previous year. The tax point here, in case of a company, there is no subdivision like ordinarily resident or not ordinarily resident. It is very important here. Now we talk about in the last slide firm or an association of person or body of individuals, which is mentioned under section 6, subsection 4. First, we will talk about resident. A firm or an association of person or body of individual is said to be resident in India if control and management of its affairs are completely or partly situated in India during the relevant previous year. Control and management is vested in hands of partners in case of firm and principal officers in case of association of person or body of individuals. So who will be non-resident if control and management of its affair are situated wholly outside India? It is a non-resident Indian. So in today's lecture, we have discussed about the residential status in detail. So Any other person which we have discussed at last in the chart in the previous slide. So any other person, when we call him a resident, any other SSC will be treated as resident in India if the control and management of its affair is situated completely or partly in India. For non-resident, if control and management of affairs of the SSC are situated completely outside India, it is a non-resident in India. So thank you. That's all from my side.